Three, two, one.
This Honorable Court of Appeals of Tennessee is now in session.
Good morning, good afternoon, rather, to the attorneys in this case. I'm sure you've already been briefed, and I'm sure the time has been reserved for rebuttal by the appellant. We will proceed in these matters as if we were actually in court. We will have the appellant present his case first, followed by the appellee, and then the rebuttal. Okay. If there's any preliminary matters before we start.
No, Your Honor.
Mr. Clerk, you may call the case.
In re Lucas H.
Attorney for the appellant.
Good afternoon, Your Honors. My name is Larry Rice. I'm a member of the Shelby County Bar, and I will be here today representing Rachel Duke.
Yes, sir.
This is an unusual civil case, in part, and most significantly in part, because there are lives at stake here. There are many lives at stake here. Giving someone a disincentive to go to rehabilitation will result in many Tennesseans dying, but we'll talk about that later. In this court, in the Culbertson case, has addressed the need for psychotherapy and the need for privacy of those psychotherapy notes. You say in Culbertson 2, 2014, effective psychotherapy depends upon an atmosphere of confidence and trust in which the patient is willing to make a frank and complete disclosure of facts, emotion, memories, and fears. Because of the sensitive nature of the problems for which individuals consult psychotherapists, disclosure of confidential communications made during counseling sessions may cause embarrassment or disgrace. For this reason, the mere possibility of disclosure may impede development of the confidential relationship necessary for successful treatment. Culbertson 1 and 2 make up the legal guts of our position. Factually, our case starts with mother and father living together and mother giving birth to Lucas in October 2016. Because of father's demeaning and controlling behavior, mother felt compelled to leave father and enter rehabilitation on January 15th, 2018. Mother refused to return to father, and father filed a dependency and neglect petition. Significantly, no one ever reported that the child was harmed, hurt, or abused in any way. Of significance, there is not even an allegation that the child has been harmed in any way. That's become very important when we look at the statute. Mother believed she needed to be a patient in rehabilitation, and she went. At the first setting of the dependency and neglect petition on February 7th, 2018, mother had completed rehab. Father agreed by consent, pending a final hearing, for mother to be the primary residential parent and have the majority of the time. Mother consented to any drug test the father requested, and as of today, almost 3 years later, father has never requested that mother take a drug test. Mother submitted on her own to 17 tests. 2 of those tests were requested by the guardian ad litem after multiple acknowledgments by mother's counsel, which is us, that we wanted the guardian ad litem to request the test, so we would have some random tests. There has been proof, there's no proof that mother has used any drugs since she went to rehabilitation on January 15th, 2018. Culbertson stresses that we should use a, quote, less intrusive means when they exist in lieu of ordering disclosure of psychologist patient privilege records. In a hearing, we dealt with the issue that the guardian ad litem instructed Ms. Duke, our client, to give her a release of all of her records. And we said, no, there's psychotherapist records that you're not entitled to. We had a hearing on that. The guardian ad litem was asked, what do you want the records for? And I quote, she said to verify that mother did go to these facilities, that she followed the recommendations, that she completed the programs, and moving forward, what would be the recommendations? Look at volume 1, page 85, lines 4 through 8. I stood up immediately and said, we will consent to those records. That information you can have. The guardian ad litem then said, no, that wasn't sufficient. She wanted all the records, even if she couldn't articulate why she wanted them. The closest she got was getting all the records is our standard practice, her standard practice. I said that twice because she said it twice on page 129 of the record and page 130 of the record. Standard practice did not justify getting the records. The only statute that can pierce this in Tennessee is 37-1-411, and it requires harm or the cause of harm to a child in any dependency and neglect proceeding resulting from a report of such harm under 37-1-403, which is the compulsory reporting statute, or a criminal prosecution for severe child abuse.
Mr. Rice,
we have here.
Mr. Rice, I'm not sure I understand. Did the guardian ad litem not give any justification for wanting the additional records if you agreed to provide the records for the purposes that she wanted?
She gave just exactly what I said. It was her standard procedure. Now, in all fairness, it's not the learned guardian ad litem you have in front of you today. It was a previous guardian ad litem, but she unfortunately is stuck in her predecessor's shoes. The statement was made twice on the record that was her standard procedure.
Did the court, did you seek the court's intervention on that?
Yes. That's where we've been going. The referee quoted the statute that I just referred to, 37-1-411, but she only quoted the first part of it. She completely ignored the harm requirement, the harm threshold that's in the second part of that first sentence. So with that, we've got a juvenile court referee short-circuiting the threshold that has to be covered before privileged records can be given out. Thank you.
I'm not sure I saw where the court addressed this specific situation that you described. In other words, where the guardian said she wanted to see the records for verification purposes, and that what programs she had completed and whatnot, and that you had agreed to that, and the court did, and the court was basically saying, no, you can have all the records. Is that what you're saying occurred?
I quoted to you directly yes, I am. And I quoted you directly from the guardian ad litem, the record, volume 1, page 85, lines 4 through 8. My response saying that we would give you these records is at page 86, lines 2 through 9.
And what was the court's response to that?
The court entered an order compelling my client to sign a release for all the records.
Without, and I mean, did it address? Did you raise this that you were willing to provide?
Yes,
part of these records?
That was done in open court. That's why it's in the record at volume 1, page 86, lines 2 through 9.
And was there a colloquy with the court about this discussion about your willingness to provide part of the records, and the GAL not justifying her need for all of the records?
Yes.
And the court's response was, no, you've got to turn over all the records?
Yes, we're basically dealing with juvenile court standard practice and the guardian ad litem standard practice. She said she would consider our proffer, but then entered an order saying, no, you have to turn over all the records.
Did the court indicate it would do an in-camera inspection, or did you request an in-camera inspection of the records?
No, sir, I did not, because as this court has said, if you'll allow me to find it, under Culbertson, this court says we find no authority for allowing the trial court to consider the substance of privileged documents in camera for the purpose of making a parental decision without giving both parties access to the documents. I believe my behavior was consistent with the requirements of Culbertson. Here's the practicality of it is we've got privileged information that we do not believe needs to come out in court. So as Culbertson too said, how does it make sense to give it to the finder of facts if you're trying to keep it from coming out? It makes no sense.
And wouldn't that be a waiver, Mr. Rice?
Yes,
Privilege.
that would be a waiver of it, and we have tried diligently not to get into any behavior that would waive it. In fact, I think we've been clear that if our offer is taken, then we want in writing that that's as far as we're going. We haven't waived anything by giving you that. Have I answered the question? All right. I'm going to take silence to mean consent, and I'm going to go on. I'm down to my last minute. In the last minute, I want to talk about an issue that's been raised by my opposing counsel about whether or not this is losing a right that cannot be retrieved. In Tennessee, I need to update something that I put in our memorandum. In 2019, 2,219 Tennesseans died as a result of drug overdose. In Nashville already this year, 411 people have died as of August in 2020. Each person's life that is lost is a hole in a family. Culbertson so aptly told us that a parent getting therapy is important for the benefit of the child. That rationale of therapy is written even larger in rehabilitation. A parent weighing whether or not to go into rehab or just keeping their kids, when you throw into the weight of that balance, oh, if you go to rehab and you're honest, like you're told to be in rehab, that will be used against you and thrown in your face in court. Therefore, the balance shifts and people are not going to be going to rehab that should be going, and they will end up contributing to an even higher death toll. So this case is important.
Your point has been made. You have time for your rebuttal.
Thank you, Your Honor. I apologize.
No problem. Okay. We'll hear from the guardian ad litem.
Good afternoon, Your Honors, and may it please the court. My name is Laura English, and I'm the guardian ad litem in this matter representing the minor child and the minor child's best interests. We are here today to ask this court to find that the trial court, in this case the circuit court, correctly denied mother's request for relief in her petition for common law writ of certiorari and request for writ of supersedeas because the mother failed to meet her burden of proof to establish the requested relief. The scope of the common law writ of certiorari is very narrow in Tennessee jurisprudence. The court held in State ex rel. Johnson versus Wolf that the Court of Appeals, or that the court can only grant relief under a common law writ of certiorari when the lower court, in this case the juvenile court, has exceeded its jurisdiction or acted illegally, and those illegal actions must amount to a fundamental illegality. The writ of certiorari at common law is not an appropriate means to seek an interlocutory review as to the intrinsic correctness of a lower court's ruling. That is the basis.
Counsel, if this proceeding is improper for mother, what remedy does she have, or does she have a remedy to contest the order of the court, of juvenile court?
She does have a remedy, Your Honor. Errors of fact or law can be corrected on an appeal taken from a final order. Common law certiorari is not an appropriate means to review an interlocutory order just for errors of fact or law. It must amount to errors that create a fundamental illegality or exceed the court's jurisdiction. Mother's recourse is to comply with the court's order for the matter to proceed according to the law and then appeal the final order if she's dissatisfied with the court's ruling. No one is questioning that juvenile court has jurisdiction over this matter. Every grounds that mother has asserted that the juvenile court violated directly relate to the intrinsic correctness of the juvenile court's ruling. The juvenile court was presented with a motion by the previous guardian ad litem to request mother to disclose her confidential medical records from her substance abuse program. The juvenile court undertook a very thorough analysis after a hearing where all parties were present and had the availability and opportunity to present their arguments, to present their evidence. And the juvenile court determined that the guardian ad litem had met her burden of proof under Tennessee Code Annotated 37-1-411, that the privilege of mother and her psychologist patient privilege could be pierced, as there was a pending dependency and neglect proceeding and harm had been alleged relating to the minor child.
Let me ask you, Ms. English, from my review, this appears to be just a routine custody matter as between parents. Other than the labeling of this petition in juvenile court as a dependency and neglect petition, what makes this a dependency and neglect petition?
The allegations that father has raised in his petition for dependency and neglect relate directly to the well-being of the child, and the father has alleged that mother's abuse of illegal substances while the child is in her physical care and custody constitutes abuse and dependency and neglect as defined by the statute, Your Honor. Tennessee Code Annotated 37-1-103, subsection A, subsection B1 defines abuse as when a child under the age of 18 is suffering from or has sustained or may be in immediate danger from a wound, injury, disability, or physical or mental condition caused by brutality, neglect, or actions or inactions of a parent, relative, guardian, or caretaker.
And what was the proof of neglect?
The proof of neglect, Your Honor, or the allegations of neglect were that the mother was using illegal substances, that she was abusing drugs while the child was in her physical care and custody. There were also allegations that the mother had taken the child with her when she was going to residences of other people and abusing these substances where these substances were present, thereby exposing the child to illegal narcotics. The definition of dependency and neglect, which is also in Title 37-1-102B, subsection 13, lists 10 grounds for dependency and neglect, 10 circumstances in which a child can be found dependent and neglected. Father alleged those in his petition, thus making this a dependency and neglect petition. That brings it within the exclusive original jurisdiction of the juvenile court. The guardian ad litem followed the procedure set forth and her duties as set forth in Tennessee Supreme Court Rule 40. She requested the records, she requested authorization. When that was denied, she came before the court as she's instructed to do and filed the proper discovery motions and requested that those records be compelled to be disclosed by the mother. The juvenile court undertook a very thorough analysis, and the question before this court is not whether the juvenile court's analysis is correct. The question is did the juvenile court have the jurisdiction to issue the order that it issued? And it did.
And let me ask, you said the juvenile court undertook a thorough analysis. is that thorough analysis evident by the order that was entered by the juvenile court, setting out its findings and conclusions?
Yes, Your Honor. That order is incredibly thorough. It sets forth everything that the juvenile court reviewed, an analysis of both the statutory and the case law, and why the juvenile court ruled the way that it did. The statutory law of Tennessee, as well as case law of Tennessee, provide 4 separate methods in which mother's confidential mental health records can be compelled to be disclosed without mother's privilege being waived. In
With
other
the
words,
provision that everything that you requested must be relevant, why would the notes of the interview between the mother and the expert be relevant? I understand you want to know if she completed the program, if there were further recommendations for her to follow, but the actual conversation that occurred between the psychologist and the mother, why would that be relevant?
it's relevant, Your Honor, because mother may or may not have made statements directly related to the harm of the child, statements of things that she did with the child in her physical care or custody that placed the child in danger, as it's defined by the Tennessee 37-1-102 B13. The statute that pierces the privilege does not require proof of harm before the privilege is pierced. What it requires is that any evidence relevant regarding the harm or the potential cause of harm is not excluded from evidence just because the privilege exists. Mother has continuously asserted that father didn't make an allegation of harm in compliance with Tennessee Code Annotated 37-1-403. But a review of that statute shows that actually father did comport with that statute as it's written. The statute states in relevant part that any person who has knowledge of or is called upon to render aid to any child who is suffering from or has sustained any wound, injury, disability, or physical or mental condition shall report such harm immediately if the harm is of such nature as to reasonably indicate that it's been caused by brutality, abuse, or neglect, or on the basis of available information reasonably appears to have been caused by brutality, abuse, or neglect. The statute then goes on to say any such person with this knowledge shall report it by telephone or otherwise to subsection A, the judge having juvenile jurisdiction over the child. That is exactly what father did. Father filed a petition before the juvenile court and alleged that the child had been harmed, that the child was dependent and neglected in the mother's care as it's defined in the statute, and is asking for the court to review the evidence and have an adjudicatory and dispositional hearing on his petition for dependency and neglect.
Let me ask you, if the father intends there was harm to the child, what, if anything, has he done to get treatment for this alleged harm to the child?
The father has stepped in and has taken at least joint custody of the child at this time. They are monitoring the child, and oftentimes we don't know exactly what kind of harm comes to a child in its developmental stages, but the case law and the history shows, Your Honor, that children who are exposed to drugs, even in their infancy, can often suffer harm that affects the development of their brain. There is plenty of information available about the trauma that children suffer and about the effects of trauma on the development of the brain.
Knowing all of that, what treatment, has the father pursued to treat what you say may have been harm to the child?
They are monitoring the child according to the pediatrician's recommendations that the child sees on a regular basis, and both mother and father are taking the child to the pediatrician and allowing the pediatrician to dictate or recommend any treatment for the child at this time.
And has any treatment been recommended?
The child is developing normally at this time.
So there's been no proof.
Let me ask one question. Do you take the position that there's no restrictions on the GAL with regard to the requirement that the records be produced? According to Mr. Rice, he indicated that the guardian, I guess it was not you, a prior guardian, stated that she wanted to see the records for verification purposes and to ensure that that the appellant had completed the programs and followed the recommendations, which really don't seem to reflect the need for the therapy notes. So is that a correct statement, or was some other reason provided for the request for all of the records, including the therapy notes?
My review of the record prior to my involvement and at the request of the previous guardian was there was a factual dispute about whether mother had actually completed the program or whether she had indeed left the program early once she learned that father had filed his petition for dependency and neglect, as the child was in his physical custody at that time. The previous guardian ad litem presented her argument to the juvenile court as to why she wanted the complete records. The court heard arguments from all parties and issued a ruling. The only question for the common law writ of certiorari before the circuit court was whether or not the court was within its jurisdiction to issue that ruling. The circuit court determined that it did not act illegally and did not exceed its jurisdiction, and that's what is before the court today, not the intrinsic correctness of the juvenile court's ruling, Your Honor.
So the question is whether or not the circuit court should have granted the writ of certiorari?
The circuit court did grant the writ of certiorari because it brought the record up to circuit court from juvenile court. The court then reviewed the entire record, including the ruling of the juvenile court, and determined that the juvenile court did not exceed its jurisdiction and did not act with fundamental illegality, which is the standard for relief under a writ of certiorari of an interlocutory ruling by a lower court.
All right,
Okay.
Thank you.
Thank you very much. Your rebuttal, Mr. Rice? Your rebuttal?
Your Honor.
Yeah.
McCall, I believe Mr. McCall gets to go before
Okay.
I get to, but I'd be delighted to take
No,
an
no.
extra turn.
If you have it divided, then it's Mr. McCall.
Thank you, Your Honors. Yes, Matt McCall, representing the father, Daniel Thomas Huck. Thank you for the time today. Ms. English is correct. This matter is before the court on a writ of certiorari, or a petition for writ of certiorari, that was filed to the Circuit Court of Shelby County, Tennessee. This is a common law writ that has been codified at Tennessee Code Annotated Section 27-8-101. That is a mechanism that allows a superior court to review an inferior court's rulings and orders to determine if the inferior court, that being the Juvenile Court of Memphis and Shelby County, Tennessee, exceeded its jurisdiction or it acted illegally when it entered the order compelling the disclosure of mother's mental health records. The issue at the trial court has always been the issue of compelled disclosure. And so in an effort to undo what the trial court had ordered after a lengthy hearing on May 24th of 2018, in which arguments were presented by myself, by the guardian, and by Mr. Rice on behalf of the mother, the trial court entered an order analyzing Section 37-1-411, analyzing Supreme Court Rule 40, analyzing Culbertson, and through the analysis, determined that these records are subject to compelled disclosure, that mother was free to maintain that she would not waive her right, but under the circumstances and as contemplated by at least 4 instances in Tennessee jurisprudence, if not 5, that these records are the subject of compelled disclosure. The first instance in which compelled disclosure can occur is what we've discussed previously, is Tennessee Code Annotated Section 37-1-411. That holds that the patient psychologist privilege is not absolute in cases of dependency and neglect. Much like the attorney-client privilege is not absolute, the statute that I've just referenced indicates that the psychologist-patient privilege is not absolute. The next instance in which compelled disclosure can occur is the revision to the standard custody factors that is relevant for this court, because this is a dependency and neglect action, although there is the alternative plea and request for relief of custody to the extent DNN is not sustained. And so under 36-6-106, subsection A8, that is the factor that contemplates compelled disclosure in custody cases as long as we comply with Title 33. Specifically, it's section 33-3-105A3, I believe. Yes, A3. That provides the mechanism and the procedure for a court to adopt to determine if compelled disclosure of these mental health records should be granted. Under Title 33, which Title 36 makes the direct reference to, the court must conduct a hearing and find that they are material to the proceedings at hand and cannot be secured any other way.
Let me ask you, Mr. McCall, you understand that the guardian ad litem can only receive these records if the DNN is sustained. Suppose it's not sustained and the records have been released. What relief does a mother have?
Well, I think Culbertson contemplates that any release that comes from compelled disclosure should have a protective order that comes with it. And so to the extent the court wanted to tie the disclosure to DNN purposes only, there can be a protective order that upon the dismissal of the DNN action, the records be returned to counsel for mother, affirmatively some sort of affidavit to affirm that they've been destroyed, that they've not been disseminated to any other party, any other lawyer. Those are the safeguards, and that is something that Culbertson contemplated.
Well, other than a DNN, the guardian ad litem wouldn't have any authority to get those records, would she?
If she is held over to the custody part, arguably she would. But under a pure DNN analysis, no, I agree with the court that her involvement would end when it is dismissed. And so therefore, if the court did not hold her over to the custody action, those records would not necessarily be available to me in the custody case unless I complied with Title 36 and Title 33 and Culbertson too. I believe all three of those provide an avenue by which someone in my situation, representing the father in this case, can ask the court for compelled disclosure. And statutory law and case law supports that under limited circumstances, we can have compelled disclosure.
Thank you, sir.
Thank you.
And Mr. Rice, your rebuttal.
Your Honor, this is the petition they filed. Nowhere in this petition does it say that Lucas has been harmed. No amendment has been filed that says Lucas has been harmed. They talk about, well, this lady supposedly, the closest they can get is that this lady supposedly used drugs. Okay. That she supposedly used drugs at some point prior to going to rehabilitation doesn't mean that the child was exposed to those drugs. They don't even plead that necessary factual bridge. So we've got no harm. Without harm, you can't use the statutory provision that the juvenile court judge has. If you didn't have that harm threshold, any party who wanted to get any other party's private therapy notes in a custody parenting case only need allege dependent and neglect, not prove it, just at least allege it. We don't even have an allegation of that here. So that's the protection that's built in there. Now, the concept that, oh, a protective order, that'll work. No, it doesn't. I've been doing this for 44 years. I've watched protective orders fail over and over again. And the argument that rational people would make is that, well, you can put the contemptor in jail. Well, you can put people who shoot each other in jail. And we found here in Shelby County, that doesn't work particularly well. Just because there's a penalty doesn't mean it's going to cause compliant behavior. And let's look at that. Once these records are out in Mr. Huck's hands, he's going to have that information and he can use that information to hurt her even just when it's between the two of them.
Why,
So-
why couldn't the protective order be for the attorney's eyes only? I mean, I'm not sure why Mr. Huck would get to look at these records anyway. I used to issue protective orders all the time that were for attorney's eyes only, and the attorneys understand the purpose of a protective order and the strength of a protective order. Are you saying that the attorneys can't be depended upon?
I'm saying that I'll address you honestly, Your Honor. I think there are significant constitutional issues and ethical issues for an attorney to have information regarding a custody and not share it with a child. Practically, I've seen this released. I am not saying that either of these other attorneys I share the screen with would, but I'm saying there are other less competent, less capable, less ethical attorneys.
Well, they're subject to professional, the Board of Professional Responsibility if they violate the protective order, aren't they?
Well, yes, they are, but they also have a problem with the Board of Responsibility for having information involving a liberty and property interest and not sharing it with their client. I think it's like where Culbertson came down and said, look, as a practical matter, doing in-camera inspections won't work. As a practical matter, the type of protective order you're referring to has flaws. I've seen it fail. Yes, there is that theoretical possibility that the attorney could be sanctioned, but I think there's a very significant ethical question about whether or not an attorney can withhold material evidence from a party involving liberty and property interest. And the Supreme Court has said very much that parenting issues are a liberty and property interest.
Wow. I got a problem with that, I'll tell you that.
Okay, thank you. Anything further?
Yes, sir, Your Honor, but my time's long gone.
Okay, thank you very much, Dan.
Thank
Your
you.
Your case now has been submitted to the panel, and you will receive our opinion within the due course of time. Thank you very much. The lawyers may be excused.
This honorable court is now adjourned.